We are on the record in CV 2017-055490, Johansson and the Castavellis. Would counsel make appearances for the plaintiff?
Good morning, Your Honor. Bryan Eastin on behalf of Donna Johansson personally and Donna Johansson as personal representative of the estate of Gary Johansson.
Thank you. I understand we also have with us the defendants, the Castavellis. Is that right?
Yes.
Okay, very good. This is the time set for a status conference, keeping us on track for our October 2nd trial. We have an 8-day trial starting October 2nd. So just checking in. So we're all on track. I've had a number of filings. As for exhibits, I've got your objections each to the exhibits. We'll take those objections as the exhibits are offered into evidence. If the documents are provided with sufficient foundation and relevance, they'll be admitted over objections. Let's talk briefly about objections. Objections should be at trial with the jury present. Should be succinctly stated. So, for example, objection foundation, objection relevance, and that's it. No speaking objections will be allowed. Don't argue why a document shouldn't be allowed. It's a simple one word. If I need more information, we'll do a bench conference outside the presence of the jury. We have headsets that we can use for that, so we can talk without the jury hearing us. I want to minimize that, though. We don't want to appear to be wasting the jury's time. We want to use their time efficiently. So again, objections will be succinctly stated, and we'll handle objections on exhibits as they come in. Defendants have requested that the court allow Christopher Adams to testify. The court's going to grant that request. Mr. Adams can testify. I anticipate, based on the objections, that Mr. Eastin will make objections to relevance, perhaps, and those will be resolved as the testimony comes out, but he will be allowed to testify. We talked last time about giving each other notice as to who's going to testify and when, at least 24 hours in advance. So both sides need to give each other your anticipated slate of witnesses for the day. And of course, the plaintiff is going first. So that'll be Mr. Eastin giving defendants his slate of witnesses each day. And then when it's defendant's chance to put on the case, you'll have to do the same, identifying the witnesses. So in particular, Christopher Adams, you'll need to let Mr. Eastin know when he's testifying so that he can adequately prepare for that testimony. We talked about courtroom demeanor last time. That sort of goes along with my notes about objections and how to make them. But we want to use the jury's time efficiently. And so we don't want to waste time with argument in the courtroom. We can have breaks to talk about whatever we need to discuss in a lengthy manner. But both sides need to, and I know this is a highly contentious case, both sides need to treat each other with respect and be professional in the courtroom. The jury will appreciate it most of all. I keep reminding you all that this is a jury case. The jury is going to decide these claims. So to the extent we can keep them engaged and not wasting their time or going off on tangents that don't help them, the better it is for you all in your presentations and arguments to the jury. We talked about voir dire. That's the question. I'll do most of the voir dire, as you'll hear, but I will give each side 30 minutes to question individual jurors. And if we need more time, if for example, one juror goes on and on and on and talks, I recognize that's not fair. So I will be fair and give you equal time with the jury in your questions, but we'll set a 30-minute per side as a starting point. I have a couple other thoughts, but I just dumped a bunch of information on you. Mr. Eastin, anything else that you need to discuss to get this trial going on October 2nd?
One of the things that's difficult for me to deal with, Your Honor, is the nomenclature that the defendants are using to identify their exhibits. So they disclosed, my best guess is over 1,500 exhibits, and they generally identify them by a file path as it's saved to their computer, making it very difficult for me to know what exhibit they're referring to. So in my objections that I stated to the court, some of those objections said that I couldn't locate the exhibit, and that's because I can't identify the nomenclature for that. And I think it will probably be difficult for the court to understand that nomenclature to the extent they're using it in their the exhibits they've identified for trial. So I recognize that some of the exhibits I objected to, I think they've identified as me being as objecting to one of my own exhibits. To that extent, of course, I would withdraw my objection if it's my exhibit, but I just want to let the court know that there's some difficulty identifying what their exhibits are. The list that they provided me in the pretrial statement does not line up where I can find things necessarily in their disclosed exhibits. So,
all right. So, one way to resolve that for both of you, obviously, it will be resolved when the exhibits are exchanged and delivered to the court. So, why don't we just set a date for that to occur, where you'll have sets of exhibits to each other and to the court. And those can be different dates if that makes sense. But my thought would be that you would exchange, so you each have the actual exhibits that you intend to offer on, pick a date, September 19th. Is that too soon, Mr. Casabelli, Mrs. Casabelli?
No.
Mr. Eastin, does that date work for you?
I'll make it work, Your Honor.
And
what are we supposed to give to him? Or why do we have to give it first?
You'll both exchange the physical exhibits that you intend to use at trial on September 19th. So it's a deadline for both of you.
Okay.
Does that work? Is that
that'll work?
Okay. So you all can figure out how to do that, but one way to do it would be, because we have to have them delivered to the court too. So you'd have a set to the court and a set for each other. Do you want to just plan on a time to meet at the court, drop off your exhibits to the clerk of the court, and also at that time exchange your exhibits with each other? Does that make sense?
Do they have to be in paper, or can it be electronic?
They have to be in paper unless they are an audio file.
Okay. There's going to be a lot of exhibits.
Yeah. Whatever. Think about it. Think about it this way, Mr. Casabelli. The jury has to look and hold and touch your exhibits. There's not an electronic system, at least at this court. So we need to get the jury physical exhibits of which you're going to use, and you each need to have those from each other as well. So it needs to be done, and I'm just trying to figure out the easiest way for you all to do it. So my proposal would be that you meet at the court, where you'll drop off a set of exhibits for the court, and at that time exchange your exhibits, a set of exhibits for each other.
What about relevant exhibits that may come up from an exhibit?
Anything that you want the opportunity to use has to be part of that set. So you may not use them all, but for example, if you have something in mind that you might use to impeach a witness, that would be among the exhibits you need to have delivered to the court and provided to counsel.
Well, how am I going to do that, Your Honor, when we wasn't allowed to get a deposition for the plaintiff?
You can't impeach anybody.
You can't impeach anybody without a deposition. which is an issue. The second issue is Mr. Eastin is stipulating to parts of documents, but not to the directly related documents that he's objecting to. So are the related documents going to be allowed as well as the ones he stipulated to?
We're not talking yet about whether they're admitted. They'll be admitted, as I said, during the trial as they're offered. There'll be an objection, and the objection will either be sustained and the exhibit is not allowed, or it'll be overruled and the objection will be allowed. What we're talking about here is having a set for the jury of everything that you potentially will use at trial. If it's not in that set, then it won't be used at trial. So that deadline will be September 19th. My suggestion is that you meet here, I'll say, noon, 1 or 2 o'clock, pick a time and get that done.
Okay.
What time, Mr. Eastin, do you think you'd like to do that?
I heard you say 2 o'clock, Your Honor, and that's acceptable.
Does that work for the Casavellis?
Yes.
All right. September 19th will be the deadline for the parties to exchange exhibits and provide exhibits to the clerk of the court, 2 p.m. on September 19th. You can do that in the courtroom and make it easy. You'll drop off a set for the court and the jury and exchange a set, and that'll be that. Okay. So that's exhibits. Thank you, Mr. Eastin. Mr. Casavelli, Mrs. Casavelli, anything?
Yes.
Go ahead.
The disclosure statements that he's finally released to us on June 7th of this year contains a lot of information that we wasn't able to access until June. And now there's issues in that we didn't get discovered on. We didn't get to object to these. He didn't disclose them in paper, and he's stated numerous times that we don't have electronic service agreements. Are those going to be allowed? Or that we have to object to each and every one of those?
Yeah, I think I said in the prior minute entry that no document will be admitted into evidence that wasn't previously disclosed during the relevant time period, during when discovery was open.
Well, then that bars the ones that he gave on June 7th, because we didn't get a lot of those.
He sent some in paper that was the actual disclosure statement without exhibits. Some he sent in, the ones that came through on that Dropbox had all the exhibits to it. Disclosure statement number 14, which we never received because it contains 483 pages of exhibits, which is a big one that he's claiming. And we didn't get that until June 7th of this year, which he claims to have disclosed to us in December of 2018 or August of 2019. But then there's an 8-month gap from the time he obtained the documents to the time he disclosed them. These are issues that's been going on for 7 years, and now it's coming time for trial.
Now, a lot of it is about protective service.
Now that it's coming time for trial, it looks like these are just going to be able to be slid right in. In fact, we didn't get to object. We didn't get to deal with this at all.
We never
at
saw
the relevant time because they wasn't disclosed at relevant. So are these going to be allowed because of that? Is what I'm asking.
Yeah, if what you're saying is that you didn't receive them at any time, they weren't disclosed to you, then they wouldn't be allowed. They won't be admitted. Mr. Eastin may have an email or something that he shows the court to show that they were transmitted, and we'll resolve it that way.
Okay. Again, no electronic service agreements. So is the court then going to allow? He claims these emails, which has been an ongoing thing. In fact, it's an email that started this whole tension between the two parties here because he altered an email back in 2018. And this was the issue. And he's been doing it all along. And now, so without an electronic service agreement, you're going to allow his disclosures because he's claiming to have sent an email?
All right. Mr. Eastin, you want to shed some light on your position on this?
Sure, Your Honor. First of all, I've never altered any emails, haven't done anything wrong that way. Every time that we sent out a disclosure statement, it went out with paper copies of what was being disclosed. And even though we didn't have an agreement to send by email, we sent by email as well on almost all of the disclosure statements. And we attached exhibits to that. I think there may have been one disclosure statement that we didn't follow up with an email. And then there is a disclosure statement they take issue with, supplemental disclosure number 5, in which they claim that no paper copies were provided because no paper copies were legitimately provided with that one. All we did in supplemental disclosure number 5 is identify an additional witness. So, of course, there would be no paper disclosure on that one.
Okay.
Your
So,
Honor?
Yeah, go ahead.
When Mr. Eastin would send any type of documentation through the mail, there's never any cancellation date that says when it was even sent or filed. On every single motion that he's filed for the majority of the 7 years, there's no court stamp at the top. We don't never get to receive that information that says when he filed it.
Or the turbo court receipt.
He used to send the turbo court receipt.
Well, the issue here is he said he sent us this. The disclosure statement 14 contained 483 pages and exhibits. That was not sent by the mail. We did not get that.
That's a big package.
So
we never got.
I understand the issue. I understand the issue.
There's going to be big issues in front of a jury, Your Honor, because of this. He's full.
Okay. So this isn't actually. I know. This is your first trial, Mr. and Mrs. Casavelli, but this isn't actually an uncommon problem. And the way to resolve it is he'll offer an exhibit that you believe you didn't receive. Your objection will be late disclosure or non-disclosure. That's the way to succinctly say it. And I'll ask Mr. Eastin to point me to the evidence that it was disclosed, and I should have a notebook of all of your disclosure statements, and he'll provide me with the proof that it was produced and disclosed when he says it was. If the court accepts the evidence, then it'll be admitted, overruling the objection. If I don't think that it was produced, there's not sufficient evidence that you received it, as you're saying, then I won't allow it. It won't be admitted. So we'll handle that objection that way.
Well, that doesn't even seem quite fair because, see, this is taking it away to the last minute. We didn't even get to argue any of this. We're trying to do it now to get it set right so that there is a fair trial and it doesn't wind up in a mistrial because this sure looks like the setup for a mistrial.
And again, Mr. Eastin has admitted many times, he even did in his last hearing with you on the 28th, that there's no electronic service agreement. So him providing emails should be a moot point because there's no electronic service agreement. And no one has waived the right to paper.
Well, the way I'm proposing to do it is the way we do it. But if you feel like there's an evidentiary issue that needs to be fleshed out.
And
that's it. There's no concession.
So we understand what you're saying, Judge. We understand it. Okay, so we're on this ride. We got it. Okay,
and what I was trying.
No, you need to understand something, Judge. We've been doing this for 7 years. We have been denied everything. The first thing here is they don't have standing to bring this. Okay?
No, they don't.
There's such things, and he can't even prove what he's got. And now you're going to weed out all of our evidence.
Hold on. I understand your frustration. I've heard this before, but we're getting to a trial. We're going to do a trial. If there's an evidentiary doubt,
without a doubt, we're going to do a trial. But I'm going to get my evidence in whether you like it or not, because it looks like to me you're going to try to get it all kicked out, all to protect a corrupt lawyer.
Okay.
Way better than you do.
I'm not sure why you feel that way, but you obviously do. So we'll see how it goes.
There's 300 documents that he has altered.
Okay.
Let me ask you something. Then tell me this. Do you understand the number sequence of a subpoena from a bank? How the number sequence is laid out? Because we do. We also understand how a request is laid out in a request from like an agency like Adult Protective Services. Okay? Which this was just disclosed to us in June, going through thousands of documents. Okay? There's late disclosure that's become an issue now. Let me tell you something about Mr. Easton's subpoena number. The 1017-2287 number is a request number from a Protective Services. Okay, not a subpoena number. and this is an issue. And he's wanting you to overlook the subpoena, allow production of documents that he has altered to try to support his frivolous claims, because they are frivolous, because what he's claiming didn't happen. And I'm sure we're going to be slapped down in the courtroom stating that we can't tell the truth and we can't produce our evidence to the jury. So we understand how this is going to go. But you need to understand something. The docket has been marked already to allow for this. This has been started years ago because, see, and whether the appellate court is going to grant the appeal, because we already see how this is going to fly. This is going to fly right towards, plaintiffs getting their way like they have for 6 years now.
There's an appeal right now, but yet we still see forging ahead. The appellate court has jurisdiction.
You may not believe what Mr. Eastin has pulled in this litigation, but it's on paperwork, every bit of it. It's easy to explain. It's easy to prove with the documents that he's even stated. He's admitted to everything wrong. He's admitted to this court a conflict of interest last July 28th. He sat there and admitted that he was representing Garbine in a case that I hired him for. And he even went as far as to tell you that, okay, yeah, that was before this case. No, it was during this case. This is the kind of thing, and the court does not want to recognize this issue.
A letter.
Oh, that's another thing. He's objecting to a letter he sent me. He authored the letter and sent to me, updating me about the status on Chris and Elaine's case, when he just allowed to testify in this case. He sent me a letter, and he's objecting to it as to attorney-client privilege. It's directed to me
as agent.
Okay.
This is the kind of ridiculous stuff that he's going to pull in the trial.
All right, folks. I've got one more issue on my agenda. I'm ordering the parties to participate in a settlement conference with a judge. I'll have an email sent to each of you letting you know how to contact that judge's office so that we can schedule it. And that'll have to be obviously scheduled in the next few weeks.
We don't feel that'll be productive, John.
Well,
he said we didn't feel
we're gonna take a shot at it. I think that
we're putting on the record now that we don't feel it'd be productive, and we're not going for any settlements. We're not. No. Not unless the court and the plaintiffs want to give us everything we ask for in our counterclaims, then we might consider that.
Well, I don't want to open up that can of worms again, but your counterclaims were dismissed.
Wait, how can you force us into a settlement when we don't want it?
All right, so you're telling me you won't participate in a settlement conference in good faith? Is that what you're saying?
I'm saying I don't want to be forced into it, but I don't want to be bound to it either. I've been in those before, and somehow it just seems to be pushed on you if you even attend.
All right, so you don't think that there's any chance that it'll be productive in limiting the issues?
I think that it would be possible if plaintiffs are willing to give us what we ask for in our counterclaims, every bit of it, and that'd be a settlement. That's $358,000.
That's the line you're drawing, that you will only agree to a settlement if plaintiffs agree to your dismissed counterclaims?
No, I'm not saying that. No, I'm not saying that.
Why?
I'm not saying that. No, I'm just saying that I'm not paying them a thing for what they've done to me for 7 years. And if the court wants to lean that way and try to take it from me, then we're just going to go absolutely full public on everything that's happened in 7 years with full documentation.
All proof.
I will be standing on every corner telling everybody what this courts have done. Every judge, every court, all the way up to the Ninth Circuit. I am tired of being bullied by the court system for a corrupt attorney who did something wrong and blaming us for it.
Okay, Mr. Eastin, you agree that? Hold on. I hear you, Mr. Eastin. I guess I am now at a loss and not sure that a settlement conference would be. I guess I'm convinced that it may not be a good use of time. But Mr. Eastin, your thoughts?
Eastin said that.
Your Honor, we would participate in a settlement conference if the court so ordered. I do take note of the fact that we are on a very short time frame to get that done, since trials meant to start in about
Okay.
three and a half weeks.
The defendants have objected to my
No, we didn't say we
suggestion.
wouldn't participate. You said we was ordering it.
If you ask, that's one thing.
Okay.
Ordering is
Well,
another.
I hear you're strenuously objecting to my order, so I will reconsider it and agree that it's not going to be productive based on what you're telling me, and we won't order it.
See, that's not what you asked us. You said you was going to order us to partake in it.
You didn't.
Right.
You didn't ask if we wanted to partake in it. You just told us we're going to. This is the way it's been for 7 years.
Okay, let me ask it.
Let me ask you this. How is it that just because we were accused of something that there's no proof of, that all of a sudden that the court just leans in that we're going to have to obey? Where's our rights in any of this? Because we haven't seen them yet.
The jury's going to decide this case, Mr. Casanova.
We'll do it. Sure. We'll partake in it.
Okay, so that's my question. Do you want to have a settlement conference, Mr. and Mrs. Casanelli, or no?
Yes, but it's not going to be binding if we can't come to an agreement.
That's
Is that
true.
right?
That's true. That's absolutely true. You will only settle to what you agree to settle. Okay.
We'll
All right. Then again, I'll have an email sent out with that judicial officer's contact information so you can schedule it. And with that, I'm going to end this conference, and we'll reconvene at the trial.
Your Honor,
Go ahead.
There's no issue.
All right, Mr. Eastin.
I do have one additional issue I wanted to bring up to the court, if I may, Your Honor.
Yeah, quickly. I have a 10:30.
You bet. When the attempted deposition of Donna Johansson was held at the courthouse back in March, I noted that on the Casavelli's laptop computers, they had imprinted something there about a website that they have put together that I think is a place where they are publishing information about this case. And if we end up not settling at the settlement conference you just ordered, and we are in fact in front of a jury, I would want the court to not allow them to have that be displayed to the jury, because the jury shouldn't be allowed to see anything other than the exhibits that come into the courtroom.
It's public record.
Okay, but I don't know anything about this website, but I'll just emphasize what I've already said and what is the law. Only the exhibits that are admitted into evidence will be shown to the jury.
So what does a sticker on a laptop have to do with evidence then?
I don't know.
Why is it trying to control that?
Nothing. I'm just short-circuiting the issue. The only thing that will be shown to the jury is admitted exhibits. So,
well, the other issue is that there is a response due to the appellate court on September 18th, and there is an appeal. Okay, so
right.
How is this going to work out when it goes
So
forward?
you're appealing the correct me if I'm wrong. You're appealing the vexatious litigant designation, correct?
Yes. You didn't follow the mandate.
Yeah. No. Listen. We're ending this conference, but I'll tell you what I've told you a few times already. The vexatious litigant designation does not impact the trial. That order has essentially been stayed. No one has been following it. The vexatious litigant order requires you to, for example, get permission to file things. We haven't been enforcing that. It's been stayed. It doesn't impact the trial date. It doesn't impact the trial date.
That's not what the appellate court said in there, and you've obviously misread it and you've done it. And this also affected our pre-filing before trial here. So putting it on the record right now that this designation that we can't file anything unless we ask permission first after we've been allowed to file in this case for 7 years, I think is a violation of procedural due process.
Yeah, and it hasn't been enforced. And
no, but you told him he didn't have to answer our motions, and he hasn't. And that violates our rights. We have rights. We have a right to know what he's got to say.
Due process says you file something
and
to respond.
So we ask for spoliation of evidence to be as a part of a jury directive and instruction, and he wants to object to it because why? We don't get timely disclosure. We don't get a deposition.
Preserving evidence that's crucial, and yet it's denied. Come on.
And yet we're restricted from filing, and he's told he don't have to answer. Do you see the
no one's
issues
restricting
here?
you, sir. No one's restricting you. No one has
No,
restricted you.
you're telling him he don't have to answer our motions that's filed. It's on the record.
If you don't answer
Yeah,
the motions, how are you supposed to
okay,
respond?
enough. We're adjourned.
Oh, sure. That's good. Run when there's a question being put before you. That's what the court's done for 7 years. Typical. Why don't you just tell us?